Zipvit Limited, Appellant, and Commissioners for Her Majesty's Revenue and Customs, Respondent. Number 2.
The judgment will be explained by Lord Sales.
The law relating to VAT can be complex, and mistakes are sometimes made in applying it. This case deals with the consequences of a particular legal mistake. The mistake related to the proper VAT treatment of individualised mail delivery services provided by Royal Mail to its customer, Zipvit Limited. Zipvit used these mail delivery services to supply goods to its customers, charging them VAT on that supply. The Revenue, Royal Mail and Zipvit all made the mistake of thinking that these mail services were exempt from VAT, just like Royal Mail's mail services provided in its role as provider of the public mail service. A later decision of the Court of Justice of the European Union showed that this was wrong. The individualised services provided to Zipvit should have been treated like an ordinary supply of services, and Royal Mail should have charged Zipvit VAT at the standard rate. When a supplier, here Royal Mail, provides ordinary services to a trader, here Zipvit, which are subject to VAT, the supplier should charge the trader the VAT on top of the commercial price for the services. The trader can in due course deduct that VAT as input tax in respect of goods which it sells to its own customer and on which it has to charge VAT in its turn. In this way, the trader recoups the VAT element which it has had to pay out. That is what should have happened here. Royal Mail should have charged Zipvit to the commercial price for its mail service plus VAT on top. Zipvit could then have reclaimed that VAT element from the revenue as input tax in respect of the supplies it made to its customers. Instead, Royal Mail only charged Zipvit the commercial price for its mail service and failed to include any charge for VAT. The Royal Mail invoices wrongly stated that the supplies were exempt, and accordingly, at the time all this was happening, Zipvit made no claim to recoup input VAT. Later on, after the judgment of the Court of Justice, the true position was clarified. However, Royal Mail did not issue further invoices to charge Zipvit with the additional sums which should have been charged as VAT. Instead, Zipvit made a claim against the revenue to treat part of the commercial price it had paid to Royal Mail for the mail delivery services as if it had been VAT in relation to a notional reduced price. So, for example, if the commercial price charged by Royal Mail was £120, Zipvit said that £20 of that should notionally be treated as if it was VAT. On this basis, Zipvit maintained that it was entitled to treat that notional VAT element, the £20 in the example, as input tax, which it was entitled to claim back from the revenue. Zipvit claims that it is entitled to do this on the basis of a true interpretation of the relevant EU directive on VAT, which is reflected in UK legislation. The directive required VAT to be charged on these Royal Mail services, and it allows VAT which is, quote, due or paid, end quote, on a supply to be recouped as input tax. Zipvit says that the £20 element must be treated as either paid or as due within the meaning of those words used in the directive. Therefore, Zipvit says, it is entitled to recover this notional VAT from the revenue as input tax, even though Royal Mail did not appreciate there was any VAT element in the price it charged and did not account to the revenue for such VAT. The revenue denied that the directive should be interpreted in this way. They say that to allow Zipvit to reclaim the notional VAT element would give it an unjustified windfall, since the effect would in substance be to reduce the price paid to Royal Mail below the true commercial price of the postal services which Zipvit received. The revenue denied that VAT has truly been paid by Zipvit in circumstances where, by mistake, none was charged. The revenue also say that under the directive, a claim can only be made for input VAT where the trader has a VAT invoice which shows the VAT which was charged, but here the invoices from Royal Mail show that no VAT was charged. In response, Zipvit added an additional point which arises under domestic law. It says that the revenue have a discretion under national legislation to accept evidence other than VAT invoices and to make repayment of tax. The revenue had failed to consider whether to exercise that discretion, and if they had done so, they should have repaid to Zipvit the amount of the notional VAT. Zipvit's claim to recover the notional VAT as input tax was rejected by the first-tier tribunal, the upper tribunal, and the Court of Appeal, but for different reasons in each case. In 2020, at the first hearing of the appeal in this court, the court found that the case law of the European Court of Justice did not provide a clear answer to the issues of EU law posed by Zipvit's claim. At that stage, the UK was still in the transitional period for its withdrawal from the European Union. Under the rules applicable at the time, this court was obliged to refer those issues to the Court of Justice to obtain its advice on them. Therefore, this court made an order for a reference to the Court of Justice. This was the last reference made by the Supreme Court. Earlier this year, the Court of Justice delivered its judgment to answer the questions which had been posed. The answer it gave on the principal issue in the case is clear. It allows this court now to decide the outcome of Zipvit's appeal without the need for further argument from the parties. This court unanimously dismisses Zipvit's appeal. On the first issue of European law, the Court of Justice ruled that in the circumstances of this case, Zipvit was not entitled to claim that the commercial price it paid to Royal Mail included an element of VAT, which should now be repaid by the revenue as input tax. Zipvit could not claim to deduct an amount of VAT for which it had not in fact been charged, and which, as a result, had not been charged to its customer, who is the ultimate consumer. VAT could not be regarded as having been included in the price paid by Zipvit to Royal Mail, and therefore had not been paid within the meaning of the directive. Nor could it be regarded as being due within the meaning of the directive, since no request for payment of VAT had been sent to Zipvit by Royal Mail. This ruling by the Court of Justice means that Zipvit has no good claim for repayment of any input VAT under the regime established by the European Directive and implemented in domestic law. In the light of that, the Court of Justice did not find it necessary to reach a conclusion on the question whether, for the purposes of the directive, Zipvit had to have VAT invoices in its hands in order to claim back input VAT, and this court likewise finds it unnecessary to reach a conclusion on that issue. That just leaves the discretion issue raised by Zipvit, which is a question of domestic law. The first-tier tribunal found that, if the revenue had considered whether to exercise its discretion to make a repayment to Zipvit, they would inevitably have decided not to do so. This court agrees with this. There is no sound basis on which it would have been appropriate to use public monies to make a repayment of notional tax to Zipvit. Zipvit had not in fact had to pay the VAT, which it was seeking to recover, on a purely notional basis. Any repayment of notional VAT would have been an unmerited windfall for Zipvit. It would mean that the state subsidised Zipvit in a way which had the effect that it paid less than the true commercial price of the Royal Mail service, and this could not be justified. For these reasons, Zipvit's appeal is dismissed.
The court will now adjourn.